Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about environmental damage and owner's liability. Cases that should have gone to the Supreme Court of Canada, but didn't. In the city of Ottawa, a condominium company contracted a third-party company to do snow removal. Unfortunately, that third-party company did not do snow removal in time to prevent an individual from slipping and falling on uncleared snow and injuring themselves. The condo company was then sued, and the court determined that they were liable. They appealed, they were still found to be reliable, they sought leave to appeal to the Supreme Court of Canada, which was dismissed. One of the arguments that they raised was the argument about environmental responsibility. That as a condo company, they had not been negligent because they had taken reasonable steps to ensure that snow was cleared, including entering into a contract with specific times and snow level conditions for which removal would be triggered, but also that they were cognizant of the environmental impact of using too much salt to get rid of snow and buildup of ice on the environment generally. And that as a condominium company, they had to balance competing interests in protecting the public from harm on the sidewalks owned by the condominium company and used by the public, and also protecting the environment from harm by anything that's done by the condominium company. And this case actually raises important issues that the Supreme Court of Canada could have gotten ahead of. We're likely to see in the coming years a significant increase in the amount of litigation that has an environmental or climate change component associated to it. We've already seen litigation like that stemming from incidents around wildfires or emergency response management or flooding, and it's likely that we're going to see more. So identifying the extent to which one's environmental responsibilities or caretaking for the environment mitigates their responsibility civilly for any harm that's done because they're engaged in a process that's meant to protect the environment, and this question of greater harm and greater good is something that the Supreme Court of Canada could have laid an early foundation for litigation that we all know is coming. And because we're only going to see an increase in climate-related emergencies and climate-related action taken by individual corporations and individual parties and governments, having a good foundation from the Supreme Court of Canada on which this litigation can be decided avoids having a multiplicity of proceedings without a lot of guidance, where courts have to get into complex assessments of to what extent your responsibility to protect the environment outweighs your responsibility to protect other people. And ultimately, it would be nice to see the Supreme Court of Canada lay a foundation for litigation that can allow that to build without having to waste precious trial court resources on determining all of these instances in the first instance. Hopefully, it doesn't take other environmental issues for the Supreme Court of Canada to finally realize the significance of environmental responsibility to civil litigation when it comes to environmental disasters or issues caused as a result of environmental incidents. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law. Thank you to Brazenbull Creative for putting together these videos. Please like, subscribe, and share with your friends.